When you bring a lawsuit seeking money as a form of compensation for harms and losses you suffered because of a doctor's carelessness, what is one of the biggest fears that most injured patients have when bringing a lawsuit? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. One of the biggest fears that I find that these injured patients have during the course of a lawsuit against their doctor is that when they are being questioned in a deposition, a pretrial question and answer session, that they say something that they believe is not accurate. That's the biggest fear, that they say something that they remember happening, but then later on they might realize, wait a second, no, that's not correct. I now remember it better now because the more I think about it, now it's a different answer. That's one of the biggest fears. So how do we get around this fear during the course of the lawsuit? I'll tell you how. Before being questioned at a deposition, which is nothing more than a pretrial question and answer session that takes place in our office, in our conference room, there's no judge there and there's no jury there. The defense attorney who represents the doctor or the hospital that you have sued will be there questioning you. I will be there, as well as a court stenographer will be there to record all of the questions you are being asked and all of the answers that you give. So now, you're being asked lots of questions over the course of many hours. In fact, you could be there all day being asked questions. So now, during the course of this question and answer session, there are instances where you say something in response to a question. And then a few minutes later, you say, oh, you know what? Wait a second. Now that I'm thinking about it, I remember that's not the correct answer. So what do you do in that instance? Can you change the answer that you gave a few minutes ago? The answer is yes, you can. And how do you actually do that? You say to the attorney, while he's questioning you, excuse me, wait a second. I just remember the question that you asked me a few minutes ago. I remember now that the answer is X, Y, and Z instead of A, B, and C. Because the more I'm thinking about it, the more I realize, yes, it's now this answer. That's one of the ways that you correct an incorrect answer. Now, you may say something that you believe is accurate and true at the time that you give it. And now, weeks later, you're sitting at home, you're reading the transcript to make sure there are no typographical errors that was recorded in the transcript, and you begin to remember something that you didn't remember at the time that you were asked this question. Can you make a change now to your testimony that you gave in our office? The answer is, yes, you can. So how do you actually do that? Well, you do that by going ahead and filling out a sheet that accompanies that transcript. It has a fancy name called an errata sheet. And what does that mean? It means make a list of any errors that you find in this transcript. Proofread it. Make sure there are no typographical errors. Make sure that everything you said here is accurate. And now, if there is something inaccurate, you can go ahead and make a change on this separate piece of paper. You will sign that piece of paper indicating that on this particular page, at this particular line, you said X, Y, and Z. And now that you think about it, months later or weeks later, the answer really is A, B, and C. And then you sign it, you sign the transcript itself, you send it back to us. Now what do? We go ahead and we take that errata sheet, that error sheet, and we make a copy of it, and then we also send it to the defense lawyer. Why do we do that? So that they recognize that there were changes made to your transcript. How does this really work at trial? If you are asked a question to which you ultimately did change your answer a few weeks later, now the attorney will go ahead and point out that fact to the jury, that at first you answered A, B, and C, and now here you are weeks later, you went ahead and changed it to X, Y, and Z. And you go ahead and say, yes, I had more time to reflect on it, and now it came back to me that yes, it is now X, Y, and Z instead of A, B, and C, or reverse, or something similar, right? So now at least it gives you an opportunity to go ahead and show to the jury that yes, I did answer that way first, but the more I thought about it, you know what? I realized that wasn't accurate, so when I had a chance to review the transcript, now I went ahead and made the change, and this is the accurate answer. So this way the jury gets to hear not just your first answer, but also the revised answer. And ultimately, it will be up to the jury to determine whether or not you are believable, whether or not you are slightly more likely right than wrong that what you are claiming is true. So we use this error sheet to go ahead and make changes in any testimony that you gave that later on you thought was inaccurate, or that there are typographical errors. Or even during the course of being questioned, now you can stop the attorney and say, oh, by the way, I just remember something I told you before. No, that's not the real answer. The real answer is X, Y, and Z. So why do I share this great information with you? I share it with you just to give you a sense of what really goes on during these pretrial question and answer sessions known as deposition in a medical malpractice case, in an accident case, or even in a wrongful death case here in New York. You know, I realize you're likely watching this because you enjoy the scenery here. No, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.